Hello viewers, in this lesson we will learn about the joint ventures and foreign collaborations in India. Objectives: to learn about the joint ventures in India, to learn about the foreign collaborations in India. This lesson explains various issues relating to the joint ventures and foreign collaborations in India. Viewers, now we will learn about the joint ventures in India. Meaning and definition. Joint ventures are one of the most popular and prime modes of entry into the global markets. In India, business is carried by private sector, that is by public and private limited companies, partnership firms, sole proprietary concerns, cooperative societies, public societies, and public sector, that is by government companies. For faster growth and development of the economy, the governments in India, both central and states, mooted the system of joint sector, where there will be participation of both the government and the private sector in the equity base of the government company. The private participation could be by private sector companies, that is, whether by private or public limited companies or the individuals. Thus, the concept of joint ventures came into vogue in India due to the larger business projects, expensive cost of technology, factors of risk and absorption of business losses. In common parlance, a joint venture can be defined as an association of two or more business entities, whether they happen to be corporate, government, individual, or any other body corporate or otherwise, with a combination of property, money, expertise, with an objective to carry out a united and single enterprise with joint proprietary rights and finally sharing of profits and losses. A joint venture could be formed either for native business or for the foreign business. Features of joint ventures. A joint venture is a separate entity. Each joint venture partner has an ownership interest as per the equity contribution. All the partners have the right of active management involvement. The partners combine their money, properties, technological expertise, other resources, and skills for common business goal. The combinations could be multifold, like between corporates, non-corporates, individuals, governments, partnerships, and various business entities. The contributions could be in the form of services also. In the joint ventures, sharing of equipment or intellectual property is also possible. Sharing of profits and losses. The purpose of joint ventures differ from case to case based on the business objectives and necessities. In India, joint ventures proved to be a success. Even in the famous government companies like Navaratnas, the government is proposing to have equity participation from private sector and also individuals. Significance of joint ventures. Financing. For ambitious and heavy projects, due to the cost factors, heavy financing is required and joint ventures provide the pooling up of the financial resources. Marketing. Joint ventures provide proper understanding of customers, market strategies, advertisement techniques, the infrastructure thereon, proper distribution channels for the products and like things. Cost effectiveness. Joint ventures facilitate the economies of scale, as for example, in case of projects involving high fixed costs, the joint ventures can provide proper economies of scale. Sharing of risk. Joint ventures share the risks of the business in capital intensive projects. The sharing of risk encourages the investors to venture into new types of business which would accelerate the growth of the economy. Issues relating to geography. Joint ventures involving foreign business with local concerns will pay rich dividends as local concerns will provide access to local markets, fill up the gaps in business planning, and provide the necessary knowledge and experience to reach the business goals. Mergers and amalgamations. In case of mergers and amalgamations of different entities, the joint ventures provide the necessary teaming up. It will cut down the cost and make the acquisition of a company by another company very smooth and easier. Employment. Joint ventures, since mostly connected with heavy projects involving very high investment, provide high employment and wider opportunities to the deserving aspirants to prove their capabilities to reach higher echelons of management. Growth of economy. Joint ventures provide high growth to the economy. The law applicable to the joint ventures. Basically, the joint venture agreements are governed by the Indian Contract Act 1872 and other legislations like the Companies Act 2013. Issuing of securities by the joint venture companies in India are governed by the Securities Contracts Regulation Act 1956, the Securities and Exchange Board of India Act 1992, the Depositories Act 1996, the Competition Act 2002, the Prevention of Money Laundering Act 2002, the Foreign Trade Development and Regulation Act 1992, the Foreign Exchange Management Act 1999, and also other related corporate laws and the various guidelines, orders, circulars framed by the Securities and Exchange Board of India and the Ministry of Corporate Affairs. Basically, the relationship between the persons involved in the joint ventures is contractual. Legally, the joint ventures are created by express contracts in written form by the partners of the joint ventures. The parties could be corporates, individuals, governments, and other persons. The joint ventures are brought into existence by a written contract for a specific business purpose. The joint ventures may have a limited lifespan, or it can be for a long term, or even for an unending term. Joint property interest subsists between the parties in the joint ventures. All fiscal laws also apply alike to the joint ventures on par with the native companies. Formation structure of joint ventures and the application of law. Normally, in the present day scenario, in India, the joint ventures are structured through the modes of corporations, companies, and partnership firms. They are narrated hereunder. Companies. Companies are the most preferred choice as the liability is limited to the capital investment of the shareholders. Mostly the companies are public limited companies in the private sector. The law governing the companies is the Companies Act 2013 and also the previous company legislations like the Companies Act 1956. The relevant companies, rules and other circulars issued by the Ministry of Corporate Affairs also govern the companies. The companies are also referred to as corporates. The companies can be government companies also, that is, from the public sector, and these companies are also termed as corporations. The Ministry of Corporate Affairs may stipulate the amount of share capital required to term a company as a corporation in the private sector. Joint ventures are entered mostly between companies. General partnerships. The joint ventures can also be entered between various persons and the partnership firms. These firms are termed as general partnerships and they are governed by the Indian Partnership Act 1932. In case of partnership, all the partners are jointly and severally liable for the debts of the firm. However, it is easy to start a partnership firm and there are no much hassles in running the firm, and in comparison with corporate taxation, the taxes imposed on a firm are less. Depending upon the size and requirement of the capital, the type of project and the fiscal benefits available, the joint ventures can be structured through partnership firms. Limited liability partnership firms. The partnership firms are also permitted to float with limited liability partnership, called in short LLP. The Limited Liability Partnership Act 2008 governs these firms. This is a new phenomenon in India and slowly these firms are becoming popular. This is a hybrid organization between the general partnership and a company. However, unlike the companies, these LLPs don't have recognition all over the world. Depending upon the place, feasibility, this mode can be used to structure a joint venture. Modes of joint ventures and the legal consequences. Operationally, the joint ventures in business practice are classified as equity joint ventures and contractual joint ventures. Equity joint venture. This mode is created wherein a separate legal entity is created as per the agreement of the parties. In this type, the parties agree to provide money or other resources as their contribution to the assets or other capital of that legal entity. The newly created entity becomes the owner of the resources and the parties hold the equity, that is, the equity shares in the company. The agreement speaks about the proportion of capital contribution and the share of each party in the profits of the company and also about the management of the company. The following are the features of this mode. The concern is a separate legal entity under joint ownership and management of the parties. Entry into the market is faster and the foreign partner would get the benefit of knowledge of the local partner and also the local laws from the local partner. The risk arising out of the sharing of intellectual property rights with the local partner is higher. The foreign party's contribution on management expertise is more, whereas the local party's contribution on employees, customers, plant and facilities is more. Equity yields higher returns to be shared between the joint venture parties. Local party provides direct access to local market to the foreign party. Foreign party bears partial risk of politically volatile market and government interference by way of controls and nationalization. Both the parties may have to face the issues under the competition law. There is joint control over corporate governance. Complexity of documentation is higher. Termination of the joint venture is in accordance with the agreement. Contractual joint ventures. In this mode, the setting up of a separate legal entity is not necessary. The existing concern enters into a joint venture agreement with the opposite person. This mode is preferred where the project has a limited activity of term or where the laws of the host country don't permit the sharing of ownership of property by foreigners, so that a separate legal entity cannot be created. The relationship in this joint venture is governed by the contract. The features of this mode are as follows. This mode does not require a separate legal entity and only a contract between a parties is required. Entry into the market is faster and the foreign party is benefited from the local party's customers connections, knowledge of competitors, local laws and practices. The costs involved are less as there is no separate legal entity. Resource commitment is low. The foreign party runs higher risk of sharing or giving away the intellectual property rights to the local party, which itself may turn out to be a competitor. The return on investment is lower as there is no equity participation, and the returns could be by way of royalties, which generally generate lower returns than equity. Foreign party cannot have direct access to the local market. Political risk is lower as the foreign party generally does not enter into a volatile market. Risk from competition law is possible as per the local competition law. The complexity of corporate governance is minimal as there is no joint corporate control. Documentation may be equally complex. Termination is as per the agreement. Termination of joint ventures and the legal formalities. The joint ventures may be terminated in accordance with the agreement. If it is based on equity participation, the venture has to be closed by initiating winding up proceedings of the separate entity. Otherwise, the party intended to drop out must transfer the equity to the other partner or to outsiders. The agreement generally contains the terms for closure of the joint venture. Several issues like breach of the covenants of the agreements by one of the parties, failure to meet research and development targets, escalation of costs, wrong estimates, unforeseen exigencies, incurring heavy losses and like ones may lead to the closure of the business units and the termination of the joint venture. Sharing of or transferring of intellectual property with the local partner sometimes may prove to be very risky and disastrous to the foreign party. Hence, proper safeguards must be ensured in the agreement. For winding up of the entity, the Companies Act 2013 applies if it takes place in India. Further, for resolution of disputes arising on the termination of the joint venture, a common law remedy has to be resorted to in civil courts or through arbitration if the agreement provides so. In case of joint ventures or ventures through wholly owned subsidiaries, WOS, with foreign persons, the relevant provisions of the Foreign Exchange Management Act 1999, the Foreign Exchange Management, Transfer or Issue of any Foreign Security Regulations 2000 and the RBI guidelines, notifications must be complied with. If the entity is a foreign company having established a place of business in India, the provisions under sections 379 to 393 of the Companies Act 2013 apply. Viewers, now we will learn about the foreign collaborations in India. Meaning and definition. Joint ventures can be formed within the country or with foreigners. Foreign collaboration necessarily is formed as an alliance between a native concern and a foreign, that is non-native entity. In business parlance, foreign collaboration is defined as an alliance incorporated for achieving a common objective collectively with the participation of resident and non-resident entities, and it includes such business activities like sharing information related to finance, technology, management, engineering, marketing and like subjects offered by a non-resident entity to a resident entity in exchange of skilled and semi-skilled labor, quality raw materials, low-cost high-tech infrastructure facilities, strategic geographic location and like ones with an approval from the governmental authority of the resident country. Basically, foreign collaboration involves mutual cooperation between one or more resident and non-resident entities. The foreign collaborations can be entered into even for academic programs, as today in India, several universities are corporatized. As for example, Sikkim Manipal University in India has entered into foreign collaboration with abroad universities like Liverpool School of Tropical Medicine, UK, University of Adelaide from Australia for academic programs. Some examples of foreign collaborations for business purpose are ICICI Lombard GIC Limited, which is a financial foreign collaboration formed between ICICI Bank Limited, India, and Fairfax Financial Holdings Limited, Canada, and ING Visa Bank Limited, which is a financial foreign collaboration formed between ING Group from Netherlands and Visa Bank from India. Features of foreign collaboration. 1. Foreign collaboration is a kind of partnership between a native entity and a foreign entity. 2. The partners support each other with their respective expertise to reach the commercial goals. 3. The partners share the profits as per the profit sharing ratio agreed upon in the contract. 4. The foreign collaborations require approval from the government. 5. Foreign collaborations provide a very wide scope for employment, finance, production, management, marketing, and other subjects of the economy and accelerate the growth of the economies of the respective countries. 6. Foreign collaborations reduce the business costs, provide pooling up of high volume of capital and supports to increase the revenue to the governments by way of taxes, duties and fees. 7. Foreign collaborations also help to achieve economic growth. 8. Foreign collaborations facilitate establishment of trade relationship among different countries and also help to utilize the resources of business in a proper way. Modus of foreign collaborations. The foreign collaborations generally formed as technical collaborations, financial collaborations, marketing collaborations and management collaborations. Mostly the collaborations center on process know-how, design know-how, engineering know-how, technology and management know-how. Application of laws. As stated afore while discussing the joint ventures, whatever laws are stated thereon are applicable in case of foreign collaborations. Basically, the foreign collaboration agreements are governed by the Indian Contract Act, all the corporate laws, and also the fiscal laws. The parties must obtain permission for the foreign collaboration from the Reserve Bank of India and also from the Department of Industries and other departments of Government of India as may be prescribed. The provisions of FEMA and RBI regulations invariably apply in case of foreign collaborations, as these involve hiring of foreign technicians, deputation of Indian personnel for training abroad, foreign testing of indigenous raw materials and products and indigenously developed technology, remittance of royalty, technical fees and like matters. The students are advised to refer to the various amendments to FEMA and RBI regulations issued from time to time to update their knowledge on joint ventures and foreign collaborations. Viewers, I hope you have enjoyed this lesson. We will meet again. Thank you.